again, everyone. Welcome to this webinar. We have Sumedha with us. Today in this webinar, we are analyzing the Environmental Impact Assessment Draft Notification of 2020. We have Sumedha with us. She is currently the academic head at Lawctopus. She's also been an environmental lawyer. She's graduated from ILS Law College Pune, did her master's from Hidayatullah National Law University Raipur. She's been a visiting faculty at a number of law schools, including ILS Law College Pune. So that's about it. I think we can start the session, Sumedha. To you, Sumedha.
Thank you, Alicia, for the introduction. Good evening, everyone. Thank you for joining us today. The topic that we have on board has been vehemently discussed in academic, law, and policy circles. Why are people not confident about this draft? What is the impact of this proposed draft of Environment Impact Assessment Notification of 2020? You may be thinking. That's exactly what we're going to discuss in this presentation today. So let's dive into the presentation and try and understand what is this new proposed draft of 2020? How is it different from the previous 2006 notification? And then come to a conclusion as to what will be the way ahead for us. Give me a moment to share my screen with you. So before we dive into what is EIA notification of 2006 and how is it different from the proposed draft of 2020, let us quickly try and revise. I'm sure most of you here are law students and they might have encountered this term before, the term EIA. But still, let us just refresh what this concept is all about, why we need EIA or Environment Impact Assessment, what are the prominent stages of EIA, and what is or where do we stand, we as a country stand internationally on this concept. So friends, EIA is nothing but a tool to reconcile the conflict between environmental protection and developmental needs. So whenever a developmental project, a plan or policy is proposed or it must be scrutinized before it is executed. So this tool of environment impact assessment takes help of experts from different fields, people who are knowledgeable, even scientists, engineers, anthropologists, and they come up with a report. This report helps us in three things. Firstly, it helps us anticipate and minimize development's negative effect on environment and society. Secondly, it also helps us make the best choice among various available options. So for example, the question before us is, say, production of electricity. So we may have different options. We may go for thermal power plant, we may go for hydroelectric power plant, or we may go for a clean source of energy, the solar power. So EIA helps us provide these various options and choose the best viable option amongst them. The third important thing that EIA helps us in is it helps in reconciling the conflict between environmental values and developmental needs. So what EIA does is that it helps us understand what will be the benefits of a project and what will be its drawbacks. So it is also called as cost and benefit analysis. So we will also understand what is the cost of a project and what is the benefit of the project. Only when the benefit of the project is more than the cost, a green signal is given for, say, a developmental project, a plan, or a policy. EIA also prevents industrial and infrastructural projects from being approved without proper oversight. So this is what is the concept of EIA, that is Environment Impact Assessment. Now let us look at what are the prominent stages in an environment impact assessment. So there are main four stages. The first is preliminary study. The second is examining the socio-economic effects of the project. Third is determining the cumulative effect of the project. And lastly, determining the transboundary impact of a project. So what happens in a preliminary study? So in a preliminary study, the project is assessed and assessed on the fact whether it has any adverse effect on the environment. If there are adverse effects, the process of EIA is necessary. The second stage is examining the effects of socio-economic importance. So for example, will this project affect the neighboring population? Will it amount to loss of job opportunities? Will it also shrink job opportunities for people? Will it affect the other infrastructural facilities? The best example that comes to my mind right now is the Bhopal Gas tragedy. So in that case, as we all know, the UCC plant was situated right in the center of a populated area. So this is one example where if at all the socio-economic effects were examined, maybe we could have not had the tragedy. The third stage of EIA is determining the cumulative effect of the project. So it may happen that prima facie, the project may appear to be harmless, but when all the resources are pumped into the venture, the cumulative effect of the project may be completely different. Here again, another example that comes to my mind is of Narmada Valley project. So one single dam project was not that harmful, but the cumulative project, the impact of the cumulative project is in front of all of us. The last stage in an EIA is determining the transboundary impact. Now, this stage is guided by the Stockholm Conference, to which India also is a party. So suppose a developmental project is proposed to be executed in India, but that project also has an impact on neighboring countries, say Nepal or say Bangladesh. Then in that case, the project is not given a green signal. Another landmark case which discusses this point is the Trail Smelter case. Now, these are the general stages of environment impact assessment. Now, many countries have come up with their own system of conducting EIA. Based on it, EIA can be either a mandatory process in a country or it can be a discretionary process. Now let us look at where do we in the sense, where does India stand over here? So do we follow a mandatory process or do we have a discretionary model? So this has not been an easy journey, friends. A journey from discretionary model to a mandatory model. So it took a number of years to move to a different model. So India followed a discretionary model till late 80s and early 90s as well. However, it felt a need as well as urgency to shift to a mandatory model. So what were the factors that led to this shift? So prominently, there were some landmark cases which triggered this change. A series of cases decided by the higher judiciary, including the Bhopal Gas case, the Silent Valley case, the Doon Valley case, and the Tanneries case, have triggered this move from a discretionary model to a mandatory model. This was also the time, now when here we're talking about a period from 1970s to 1990s. So if you remember, all these cases were decided during this time frame. This was also the time when there were a lot of international developments happening. Stockholm Conference happened in the year 1972. Rio Conference happened in the year 1992. So these two major conferences also had an impact on this shift, India moving from a discretionary model to a mandatory model. Thus, taking help of Section 3 of Environment Protection Act, the first EIA notification was introduced in 1994. This first notification was later on substituted by a revised and modified notification in the year 2006. This notification of 2006 is the current notification that we are following. The proposed notification will, if accepted, will replace this existing 2006 notification. Now, what is this EIA notification of 2006? What are the key features of this EIA notification? So the key features of EIA notification 2006. This notification mandates a clearance for all the new projects, and it mandates that all the new projects should go for a prior environmental clearance. This is something that has been proposed to be changed in the new notification. So all the new projects, be it developmental projects, be it infrastructure projects, be it construction projects, all have to get a prior environmental clearance. That is environmental clearance before the project is executed. Environmental clearance is not only required for new projects, but also for expansion or modernization of existing projects or activities. Environment clearance is also required if there is any change in existing manufacturing units beyond the specified range. So when an environmental clearance is granted, that environmental clearance comes with few conditions. That environmental clearance also gives a specified range to which a project can be modified or expanded. Now, if a change is beyond the specified range, a clearance is required. The EIA notification, again, this is a very novel feature of EIA notification. It categorizes all the projects as projects A and projects B. This categorization is based on the spatial extent of potential impacts, potential impact on health, natural and man-made resources. So A projects or projects A require clearance from the Ministry of Environment, Forest and Climate Change. And this clearance is given based on recommendations of the EAC, that is Expert Appraisal Committee. B projects require prior clearance from the state authority, and this decision is based on the State Expert Appraisal Committee. Now let us look at how the EIA 2006 notification proceeds in giving an environmental clearance. So the process is broadly divided under 5 heads. So whenever a new project is proposed, the first stage that it goes for, if it is a B project, the first stage is of screening. So what is a screening? Screening is nothing but determining whether a certain project requires an EIA or not. If this project requires an EIA, it is categorized under the title B1. If it does not require an EIA, it is categorized as B2. The second stage is scoping. Now, friends, please note that all the projects that are categorized as B2 projects do not go for the next 2 stages, that is stage of scoping and stage of public consultation. So it is only projects A. Projects A again are the projects which are given clearance by the Ministry of Environment, Forest and Climate Change, and B1 projects are given clearances from the state authority. So the scoping is only done for projects A and B1 projects. So EAC, that is Expert Appraisal Committee, and SEAC, that is addressing all the relevant environmental concerns. So what this authority will do is that it will jot down all the important points on which assessment or analysis is to be made. Now these TORs are arrived at based on the application form submitted by the project proponent, TORs proposed by the applicant, and other available information which may be in the public domain or which is collected by the subgroups constituted by EAC or SEAC. The next stage, and a very important one, is that of public consultation. Now, when we talk of public consultation, there are two most important points. The first is that it includes a public hearing, and secondly, obtaining the responses in writing from the persons who are concerned in that project. So when we talk of public consultation, we are talking about these two things, that is public hearing and obtaining the responses in writing. Now, what happens after this is that all these responses received from the people are forwarded to the applicant to modify their draft as well as environment management plan. After this is done, comes the stage of appraisal. Now, this stage is for all the projects, A projects, B1 projects, as well as B2 projects. So EAC and SEAC will appraise all the material in front of them and finally give their decision. Now, this is the process for a new project. What is the procedure for an expansion of a project or modernization of an existing project? So in such a scenario, EAC and SEAC will directly do the appraisal. So here, screening, scoping, public consultation are not involved. If the project is to be expanded, this will directly come for appraisal before the EAC and SEAC. Now, once the project comes for appraisal, a due diligence is done, including whether a certain expansion project requires a public consultation or not. And if it is required, the project will have a public consultation, and based on all the data available with the EAC and SEAC, the clearance will be granted. Now, a novel feature of 2006 notification is that it provides for a post-clearance monitoring. So the role of these authorities, regulatory authorities, do not stop after granting a clearance or environmental clearance. It continues even after that. And that is done by asking a half-yearly compliance report from the project proponent. So this compliance report has to be submitted by the project proponent. And what goes into this report is whether they are following the conditions mentioned in the environmental clearance, whether there is any violation, so on and so forth. So this is the procedure mentioned under the 2006 notification. Now, let's have a poll. Now, this incident or this tragedy happened a few months back. How many of you remember the accident that happened in LG Polymers plant in Visakhapatnam? Anisha, can we have a poll, please?
Yes, so I have launched the poll. It is available on your screen, so you can see your answers.
Yes. Okay, so around 86% of you know what this case is all about. But for those of my friends who do not know or who do not exactly remember what happened in this case, the polymers plant owned by LG, situated in Visakhapatnam, had a gas leak in month of May. Now, it led to death of around 15 people and injured many. Now, the fact over here is that this polymer plant owned by LG operated for around 2 decades without any environmental clearance. Now let us keep this case or incident in our mind when we proceed in the presentation, because time and again we will be coming back to what happened in month of May. After understanding the EIA notification of 2006, now let us move to the proposed draft of 2020. Why are people not confident about this draft, or why are people not sure of what will be the impacts of this draft? We will be discussing henceforth. Now, this draft of 2020 is introduced to replace the existing draft of 2006, existing notification of 2006. The preamble of this draft intends to bring transparency and expedite the process of granting environmental clearance. And as I said earlier, and as we all know, it is highly criticized in academia, law, and policy circles. Now, what are the points on which this draft has been discussed or deliberated upon? The first point is that people say that this notification attempts to weaken environmental regulation and silence affected communities. It also neglects the balance between sustainable development and environment protection and favor the industries. This draft, it is claimed, deviates from the Environment Protection Act of 1986 as well as international commitments, mainly commitments under Stockholm Conference, Rio Conference, CBD, UNFCCC, that is United Nations Framework Convention on Climate Change. And lastly, it destroys the model of protection and care and irreversibly affects environment and increases hazards to human life. Now, we will be analyzing the major changes introduced under this draft of 2020 under the following slides. But before that, I have a question for you. Now, it is said that this draft is nothing but consolidation of all the earlier amendments to the 2006 notification, as well as court orders on the topic of EIA. Now, do you think that such a consolidation, which diverts from the spirit of EIA law and lacks a regulatory impact assessment, succeed? Now, before you answer this, let me quickly tell you what is a regulatory impact assessment. So this is an internationally recognized concept. So whenever a new law is proposed or there are discussions going on for proposing a new law, an assessment, an impact assessment is done as to how far the draft is justified, how far that law will be justified, and what will be the performance of that law or regulation. Now, in this case, unfortunately, the new draft has not been gone through RIA, that is Regulatory Impact Assessment. Now, let's have a poll, and I would also like to know whether you think that consolidating various amendments as well as court orders will help in succeeding the law. Yes, Anisha, can we have a poll, please? Yes. So, yeah. So around 57% of you think that proposing a draft which only consolidates the earlier amendments, but if it goes against the spirit of the earlier law, it may not succeed. So this is something that we have to wait for and see how things proceed. But yeah, this is a point to be pondered upon, whether just a consolidation of laws or consolidation of amendments will help a law to succeed. Now let us point by point look at what are the changes in this proposed draft, or what are the points of low confidence, why people think that this proposed notification may not work the way it is expected to work. So the first point of low confidence is that it relaxes the mandatory prior environmental clearance and allows post facto clearance. So let us pause for a minute here and try to understand what these two terms are. And I would like to again take you back to the 2006 notification. So if you remember, under 2006 notification, whenever a new project is proposed, that new project has to go through a prior environmental clearance, which is nothing but an environmental clearance granted before starting or before executing a project. Now, what this 2020 notification does is that it relaxes this mandatory requirement and allows post facto clearance. It means that a project proponent can start with the project and later on, say after 10 years, say after 15 years, say after 20 years, even 50 years later, apply for a post facto clearance. So this is what the draft of 2020 has allowed us to do. So it attempts to legalizing the projects that have already caused a great deal of harm and have been operating without EIA. Now this is most dangerous. Why? Again, we go back to the LG plant case, the gas leak at LG plant in Visakhapatnam. Another incident that happened a few months back is a blowout at Oil India Limited in Assam. So even this plant operated for around 15 years without an environmental clearance. So both these cases are eye-opener as to what will happen if this concept of post facto clearance is introduced in our jurisprudence. Recently, even our Supreme Court had an opportunity to put forth its opinion on the post facto clearance on the environmental projects. So the Supreme Court in this case stated that ex post facto clearance is contrary to the precautionary principle as well as to the principle of sustainable development. Now, friends, we will be coming to this point in few moments, but as of now, just remember that India is under international obligation to follow this concept of precautionary principle as well as of sustainable development. Now, if we have to ensure that these two principles are followed or are respected in our country, we cannot let go of prior environmental clearance. Why? We will be discussing it in our coming slides. So this was point number one. Point number two is that the proposed draft dilutes public consultation. Now again, let us go back to the 2006 notification. We saw that public consultation is again mandatory and a project will have to go through public consultation. Now, this proposed draft expands the list of projects that are exempted from public consultation. Under 2006 draft, only B2 projects were exempted, but under this proposed draft, the list has been expanded. Even construction projects are not required to go through the steps of public consultation. Now, another project that is coming up, and again, it is under light, is the Central Vista project in Delhi. Now, friends, if this proposed draft is notified and accepted, the project proponents of this project will not have to undergo the public scrutiny. The draft EIA notification of 2020 also reduces the period of public consultation. So under the 2006 notification, this period was of 30 days. Now it has been reduced to 20 days. The process also has to be completed within 40 days as against 45 days under the 2006 notification. The next change proposed by the new draft is that only limited information may be made available to the public for consultation. Now, friends, please understand that when a project is proposed for a public consultation, unless and until people know what the project is about, and unless and until they have all the required information, they are unable or they are incapable of giving their responses or giving their feedback. The next change this change has this step goes against two very landmark decisions of the Supreme Court. The first is the Adivasi Mazdoor Kisan Ekta Sangathan, and the second is the infamous Niyamgiri case. In both these cases, the Supreme Court has lauded and appreciated the impact of public consultation. If you remember, in both these cases, it was the people who fought for their rights. To limit public consultation means to silence voices that are barely heard otherwise. Now, let's point or the next change introduced under the new proposed draft. It exempts around 40 projects from prior environmental clearance list. Now, these projects are notably from the renewable energy sector, even solar thermal power projects, solar parks, and coal and non-coal mineral projects are exempted from having a prior environmental clearance. The problem here is that the draft does not disclose the criteria for such exemption. So if you remember the 2006 notification, there is a reason or criteria of categorizing the projects under category A, category B1, and category B2. But here, there is no such criteria given. No cost benefit analysis is required, no threshold limit, or for that matter, any criteria to categorize projects into A, B, or B2. Now, as students of law, you may understand that this goes against the basic tenets of administrative law, which requires exemptions to be culled out based on sound reasons. So if there are exceptions, there should be reasoning given for those exceptions. Now, if you think for a bit, the rationale for doing so seems to be the notion that solar energy projects are generally cleaner projects as compared to thermal power plant or hydroelectric plant, as well as better for climate. However, we must also understand that even for a solar energy project, there are requirements of large land area, diversion of agricultural land, so on and so forth. So even a solar energy project may have to undergo an environmental clearance, but the proposed draft fails to give us reasons why it has been exempted from a prior environmental clearance. The fourth important point is that this draft contradicts the principles of international environmental law. As briefly discussed few minutes ago, India is under international obligation to follow few principles laid down under Stockholm Conference and Rio Conference. India was amongst the first few countries who participated and signed the documents laid down in these conferences. So the Rio Declaration, which is again a document which was put forth in the Rio Conference, this declaration signed by India enunciates a catalog of environmental principles. These principles include sustainable development, precautionary principle, as well as environmental impact assessment. So, we cannot go against these principles. In addition to that, many of the multilateral environmental agreements or MEAs to which India is a party, including the CBD, that is Convention on Biological Diversity, and UNFCCC, that is United Nations Framework Convention on Climate Change, contains a requirement to have a prior EIA in situations having a significant threat to the environment. Now, interestingly, these principles are no more principles of international environmental law. They are now very much part of our domestic legal jurisprudence. So students of law will remember this very famous case of Fellow Citizens Welfare Forum versus Union of India. Through this case, the Supreme Court for the first time incorporated these principles, and these principles became the law of the land back then. And after the enactment of NGT Act, these principles are now explicit part of India's legislative framework. A point to be noted here is that without an effective EIA, it is difficult to justify whether a project is in line with sustainable development or precautionary principle. Thus, any dilution of the EIA and public consultation is a step away from international legal obligations. Now, in addition to these four major points, there are a few other points as well, which have been discussed, and there have been suggestions that these points should be corrected. The first amongst these other points is that the draft notification allows EIA report based on one season baseline data. Now, under the 2006 notification, whenever a project proponent comes up with an EIA report, that EIA report is based on data collected for minimum 3 seasons. Now, that is the most scientific way of analyzing the data and coming up with a proper impact assessment. So, for example, you cannot assess whether there will be floods based on data of rainy season. You need to also have data from other seasons. But this draft notification allows an EIA report based on one season baseline data. Now, most of the scientists say that this is unscientific way of coming up with an EIA. The next point is that the environmental clearances can be granted on project level basis. What do we mean by project level basis? Now, if you remember the first or second slide, one of the most important steps in an EIA is the cumulative impact assessment. So that means the project as a whole needs to be assessed, should be assessed. Just assessing one project out of 10 projects is not a scientific way of granting an environmental clearance. The next point is that this draft misses out on concepts or issues of assessing impact on society, climate, and biodiversity. Another change introduced through this draft notification of 2020 is that it changes the post monitoring mechanism. So under the 2006 notification, the project proponent, after getting an environmental clearance, was mandated to provide a compliance report after every 6 months. This has been changed for 1 year. The next point is that who what's if there is any violation of the environmental clearance. Under the earlier notification, any concerned person or any organization could report violation of environmental clearance. Under this draft, violations can be reported only by government representatives or project proponents. Now, let us pause and think, if I own a coal mine and if I am violating any of the conditions stated in an environmental clearance granted to me, will I really go up and say that I have violated a certain clause under my environmental clearance? So, how this thing is going to work out, we really need to wait and see. The last important point which I wanted to bring in front of you is that uh, EIA covers different types of projects. So EIA covers mining projects, EIA covers uh, uh, projects related to ports, EIA covers infrastructural projects, EIA covers construction projects. Now, these projects are not only governed by environmental laws, but few specialized legislations as well. For example, mining is controlled by MMDR Act. Ports and harbors are protected under Ports and or they are regulated by Ports and Harbors Act. Now, the proposed notification is silent on such conflicts which are inherent and which needs to be addressed and which was expected. So if a new notification is proposed, we expect that the earlier issues are resolved in the fresh notification. However, we see that the proposed notification nowhere talks about this problem. Another question for you, and I'm sure many of you will have different opinions on it, but yes, we do welcome different opinions. So this draft, this 2020 draft notification of EIA was introduced in month of March. Now, this is a time when the world is facing massive economic slowdown. So there's this argument that if the draft of 2020 is notified, it will boost economic growth. What do you think? Will it really boost economic growth? Can a simple thing like environmental approvals boost the economy? I would really like to know your opinions. Anisha, can we raise a poll, please?
Sumedha, do you mind taking the questions from the Q&A
Sure, we
box?
can take questions. Yes.
Okay. So Gayatri is asking, can you please explain post facto clearance again?
Yes, sure, Gayatri. So I would again like to take you back to the 2006 notification, which we just discussed in the earlier slides. So whenever a new project is proposed, it has to get an environmental clearance, going through the various stages that we discussed in the earlier slides. Now, what is proposed in this new draft is that prior environmental clearance is not required. So if a project proponent wishes to have his own coal mine, he need not take an environmental clearance, which was a mandatory step under the earlier notification of 2006. He can directly start executing his project, and maybe say once when he gets stable in that business or in that project, he may then later on post facto apply for an environmental clearance for a period starting from a period before when he executed that project. So suppose a person starts a mining activity today, he may apply for a post facto clearance in 2025, starting from today. So that is what you understand by the concept of post facto clearance. So so it is similar to the to the term retrospective. So that is what has been introduced under the 2020 notification.
Okay. So Shikha has a question. She's asking if the UCC plant was in the midst of a populated area, how did it pass the EIA?
Can you repeat the question, Anisha? I
Yeah,
did not hear it properly.
Shikha is asking if the UCC plant was in the midst of a populated area, how did it pass the EIA?
Correct. So Shikha, we need to understand the time frame. So this tragedy happened back in the year 1984. So that was the time when India followed a discretionary model of environmental impact assessment. So the first EIA notification was introduced only in the year 1994. There was no mandatory requirement of environment impact assessment prior to that. So this tragedy is what triggered India's move from a discretionary model of environment impact assessment to a mandatory model. So yeah, I guess that answers the question.
Okay, so I think Sumedha, we have got. Uh, I'm ending the poll. We've got
Yeah,
quite a lot of responses.
yeah. So, friends, these are a few points that I wanted to put forth in front of you. Now, yeah. Now, there have been some developments in past 1 month on this draft. So the draft was introduced in the month of March, but it has been challenged at number of forums. There have been PIL filed in high courts across country. Um, Delhi High Court has given its decision. A PIL is pending before the Madras High Court. A PIL is also pending in front of Karnataka High Court. So let us try to understand what was held by the Delhi High Court on this draft. So the first issue that was raised before the Delhi High Court was with reference to duration in which the people were asked to submit their responses, whether the draft should be notified or not. Earlier, the last date for submitting the responses was in June. So Delhi High Court extended this last day of getting responses to August 11. But it also directed something else. It directed that this draft 2020 should be translated in all the languages under 8th schedule of the Constitution. Now, this 8th schedule has approximately 22 languages, 22 regional languages, and the ministry was, or the central government was asked to translate this draft into regional languages. However, as of now, the draft has been translated only in 3 languages, Marathi, Odia, and Nepali. Now, the same issue was also put forth before the Madras High Court, wherein the Madras High Court did question the central government as to why the draft has not been translated and published in Tamil. So the hearings are still going on, and we will surely come to know as to what is the outcome of that case. Now, this is the development that happened yesterday. A similar PIL has been filed before the Karnataka High Court. And the Karnataka High Court has observed that draft EIA cannot be finalized and notified as a law till wide publicity is given to the draft. So, according to the Karnataka High Court, the draft should be made available in regional languages. And a stay has been put till the next hearing, which is scheduled on 7th of September 2020. So this day of this date of receiving the responses has been extended from August 11 to September 7th, and people can still send their responses till date. Now, what will be the outcome? How far the draft will be notified? Whether there will be changes? We do not know, and maybe waiting is the only option that we have. But where do we go from here is something that we need to ask ourselves. Can we really afford compromising the environment on false notions of development, especially when we have been witnessing its repercussion in the forms of climate change, extreme weather conditions, floods happening all over India, and now COVID-19? So I will stop my presentation here. Let us ponder on this thought for a bit, and maybe we can have few questions. Anisha, are there any questions?
Yes.
Yes, also, just a moment. If at all any one of you is willing to send your responses, this is the mail ID on which you can submit your responses. Yes, Anisha.
Okay. So we have a lot of questions. I'll just read it out to you. So Achal is asking, hello ma'am, in what terms do we consider the cost and benefit of a project?
In what terms?
Yeah.
Yeah, so generally there are economic formulas for it, but there are number of things that are considered when a cost benefit analysis is conducted. So not only the impact on environment, but the impact on society, the impact on uh, jobs available to the people around them, the impact on biodiversity, the impact on climate, weather. All these factors are considered when a cost benefit analysis is done. So, for example, even if few trees are to be cut, it is basically considered to be a cost of that project. So that is how a cost benefit. There are economic formulas for it. I'm not an expert of economics, but yes, there are formulas.
So Dr. H.K. Das is asking for clearance of V1 and V2 projects under state government. Who is the authority?
For granting the clearance,
So it's just Mr. H.K. Das. If you can just post it on the chat box.
okay, so see, the appraisal is done by state expert appraisal committee, but the clearance is granted by the state environment impact assessment authority, or also known as SEIAA. So I guess that answers the question.
So Pavitran is asking, what's the stand of present day ruling party on this draft? Are they taking measures to preserve our environment by correcting the mistakes in this draft?
Um, we will come to know about this in coming days, maybe once these different high courts give their decision and once the date for giving the responses is over. So maybe we will come to know of this stand after September 7th.
Okay. So another question is from Karthik. Do you think the public consultation in the 2006 EIA was effective? Some of the projects went ahead even after objection from public.
Exactly. So that is what I wanted to focus in my presentation, that even when the public consultation was mandatory under the 2006 notification, it was not implemented properly. So to give you an illustration, when the country was struggling with the lockdown and COVID-19, uh, in Maharashtra, public consultations happened through Zoom. Now, the data shows that not many people were able to access or participate in this public consultation. So, yeah, these are the issues that need to be rectified when we are proposing a new draft.
So this question is from Devika. She's asking, ma'am, would you please explain the concept of project level clearing again?
Project?
Project level clearing again.
Project level clearing. Prior environmental clearance? Do you mean prior environmental clearance?
Devika, can you, if you're
Yeah, Devika,
still
can you
in the
please
same,
put it again in the chat box or in the Q&A?
yeah. So there's one question from Pankhudi. So Pankhudi is asking, how do we regulate the pollution from ships?
Pollution from ships.
Yeah.
So, are we talking about oil spills here? If yes, there are rules and regulations under the Environment Protection Act. So there are laws regarding that. And of course, provided these laws will be applicable, provided EIA or environmental clearance uh, was taken before starting such projects.
So there's a question from anonymous attendee. Uh, the question is, what are your views on various PILs seeking translation of EIA in regional language? If done, this creates a precedent whereby all the drafts issued by Government of India would be required to translate in all regional language and thereby increase workload tremendously.
Yes, and the same argument was made by the government. But please understand that the 2006 notification also mandates translation of documents in a language which is understood by the people. So, for example, in the Niyamgiri case, that is the Vedanta case, the people who are affected by that project were Adivasis, were tribal people, and were not in a position to understand, or for that matter, even read a draft in English. So, if we aim at having a true public consultation, that people should know what the issue is in the first place. And they will only come to know what the issue is only when they are able to understand that draft. So therefore, it is necessary that drafts should be translated in a language that people understand.
Okay. So there's a question from Dhwani. She is asking, given the Supreme Court judgment in April that states that ex post facto clearance is contrary to law, if it is reintroduced in the final draft, will it hold good in law?
Anish, I was not able to hear the first part of the question.
Okay. So I'll repeat it for you. Yeah. So Dhwani is asking, given the Supreme Court judgment in April that states that ex post facto clearance is contrary to law, if it is reintroduced in the final draft, will it hold good in law?
Again, the notification can be challenged, but yes, it can be challenged later on.
So we have a question from Ayushi. She's asking, Fortune for Friday, Let India Breathe, and many other websites have been blocked by Prakash Javadekar, alleging that these websites are unlawful and threatening the unity and integrity of India. What are your views about this? I personally don't think that protesting against EIA leads to terrorist activity.
Can you repeat the second part of the question?
Okay. So Ayushi is asking, uh, Fortune for Friday, Let India Breathe, and many other websites have been blocked by Prakash Javadekar, alleging that these websites are unlawful and threatening the unity and integrity of India. What are your views about this? I personally don't think that protesting against EIA leads to terrorist activity.
Leads to?
Terrorist activity.
Okay. See, I think a democratic process requires people to know both the pros as well as cons of the draft. So, yeah, I think this step should not have been taken. Even when a person is trying to understand whether he's pro or against, he will make that decision on his own. But the information should be open to everybody. And even now, that's our fundamental right under Constitution. Yeah.
So there's a question from Isha. She's asking, are there any positives in the new EIA, if any? So,
Yes, one of the positive uh, of from this draft is that uh, it has expanded the scope of projects covered under EIA. So that is one very important contribution of this draft, that it has included more and more projects under the scope of EIA. Yeah.
so we have a
And
question.
also most of the terms are defined under this notification. So if you will compare this draft with the earlier notification of 2006, you see that this draft has given a long list of definitions and has clarified what certain terms mean in the draft. Yeah.
So there's a question from anonymous attendee again. So, like the question is there any chances of withdrawing this EIA 2020 from our government side? Because here in South India, several volunteers, organizations, environmentalists are opposing this draft from the day of its release. What's the need for our government to release this draft in this situation?
That is the reason why our high courts have interfered and the date has been extended. Yeah.
Okay. So we again have a question from Dr. H.K. Das. He's asking, is health impact assessment are also incorporated in clearance of environmental projects? If yes, who undertakes the same for A, B1 and B2 projects?
Yes. So ideally, health impact assessment should be done, but the draft misses that point. Yeah.
So there's another question. In areas covered under the sixth schedule, will any project needs to get the NOC from the Autonomous District Council?
Can you repeat the question, Anisha?
Okay. In areas covered under the sixth schedule, will any project needs to get the NOC from the Autonomous District Council?
Autonomous District Council.
Autonomous District Council. Yeah.
Uh, I did not get the question. I mean, what do you mean by? I need a little more clarification on what do you mean by district council? Uh, because see, all these projects are governed by number of legislations. So EIA notification is just one law uh, which regulates these projects. So there are other number of legislations which are in place, and those legislations do regulate these projects. But when it comes to EIA, a procedure under EIA is to be followed. Yeah.
So Arunika is asking, is post facto applicable only on exempted projects or on all projects?
All projects. All projects.
So
So
what
interestingly, even the LG polymers plant applied for a post facto clearance.
so Arijit is asking, ma'am, there's also something which the government refers to as strategic considerations for which there will be no EIA. Please do elaborate on that.
Um, well, the term has not been defined under the draft, and that remains a gray area in the draft. So yes, projects of national security, defense projects, and projects involving strategic planning have been exempted from EIA. But again, the term strategic planning has not been defined under the draft. So that is a gray area. Yeah.
So we have another question from Karthik. Karthik is asking, I hear news that industries stating that EC was granted when they constructed in industrial zone, but later due to urbanization and migrant residential area was constructed near industrial zone. Is it true? What is your view on this?
Can you again repeat the first part of the question?
Yeah. So Karthik is asking, I hear news that industries are stating that EC was granted when they constructed in industrial zone, but later due to urbanization and migrant residential area was constructed near industrial zone. Is it true? What are your views?
Correct. So, Kati, there are two things that are to be considered here. EIA is given for a or environmental clearance is given for a limited period of time. So you need to again apply once that period is over. And again, your project will have to go through the stages mentioned under the 2006 legislation, the notification. Now, as regards uh, expanding boundaries of our cities and metros, uh, if this thing is reflected in the DP, then maybe yes, a new environmental clearance needs to be sought in that case.
So Gayatri is asking, I would like to question what is development? Wholesome development under Article 21. What is the say of Pollution Control Board and green benches like NG?
Yes, so all the courts have now come to, I mean, this long debated issue of environment versus development has, for the courts, now that dispute has been resolved. Whenever there's a question of development versus environment, the courts have given a priority to environment. Uh, and what was the second part of the question?
Uh, what is the stand of NGT and Pollution Control Board
Yes, so
about development?
yeah, so that is the stand that firstly, uh, good EIA is not against good development. So yeah, that would be my answer to it.
Okay. So there's another question. This is from Meghna. She's asking, do the draft of 2020 need to follow the policies of 2006 CIA notification?
The 2020 draft is proposed to replace the 2006 notification
So,
completely. Yes. Yeah.
okay. So there's another question from anonymous attendee. There is also a risk of wrong oblique improper translation, and this could change the message conveyed by draft regulation. What is your take on this?
Uh, when there's a demand that a draft is to be translated, it is expected that there will be no mistakes. But if there are any mistakes, then a proper forum needs to be, you need to approach the proper forum.
So, yeah, there's a question from Ayushi. She's asking, ESE and SEAC come under public authority. Can we file RTI for getting information about EIA report of any project?
Yeah. Yeah.
So there's a question from Pooja. She's asking, ma'am, in the recent times, we are witnessing the rise of many new projects such as Vikramshila, what is- Vikramshila Gangetic Dolphin Observatory or India's first lichen park in Kumaon. Do you think these are definitely a ray of hope in this era when environmental degradation have reached alarming dimensions?
Yes, I do. Yeah.
Okay. So another question is whether the proposed draft can achieve sustainable development goals.
So that is what I have also discussed in the presentation, that if you dilute EIA, you cannot have sustainable development. So to have sustainable development, to ensure that precautionary principle is followed, you need to have good EIA. If you dilute it, you cannot have sustainable development.
Right. So we have a question from Amardeep. He's asking, uh, how many democracies in the world have public consultation process for approving industrial projects?
Uh, Many of them, many of them. As I said, public consultation or getting responses from the people who will be directly affected by that project is a mandatory step, internationally recognized mandatory step under EIA. Yeah.
Okay.
And even under the international conventions and documents and multilateral agreements.
So there's a question: can ascribing legal personality to natural bodies like rivers, mountains, etc., positively impact EIA application in future?
Uh, though there has not been a case where the EIA was never in picture when uh, the resources were personified. But yes, personification of natural resources, be it rivers, be it mountains, have helped in protecting their degradation, yeah, and conserving them as well. So, for example, there's a very good illustration from New Zealand where a river was personified and it has had positive impacts. And so is the case with Niyamgiri in India. Yeah.
So there's a question. Achal is asking: can a draft be accepted even when it gains the international? Sorry, even when it is against the international obligations?
Uh, if it is accepted, we will be answerable in international forums.
Okay. So Piyush is asking if the notification is countering various international norms and especially contrary to various court orders, do you think the drafting panel did grave mistake in formulating such a contradictory reform under democratic setup? And if they did, what may be the criteria they came to the position of drafting such a notification?
Can you please repeat this question?
Yeah. So Piyush is asking if the notification is countering various international norms and especially contrary to various court orders, do you think the drafting panel did grave mistake in formulating such a contradictory reform under democratic setup? And if they did, what may be the criteria they came to the position of drafting such a notification?
See, they have missed few points, but the draft has not been notified yet. So there is still scope for incorporating those changes in the draft. So the gaps there's still scope for filling in those gaps.
What is the say of NGT on this draft?
NJT has recently made a comment on it that EIA should not be diluted. The EIA process should not be diluted.
So, what about the absolute liability principle? Is the draft not against it? Question.
Um, I am not sure how far absolute liability will come into picture here. I mean, maybe the question needs a little bit of clarification.
So, Gayatri, if you
Gayatri,
can,
can you please, yeah. I mean, please elaborate how absolute liability will come into picture when we are, I mean, vis-a-vis EIA.
right. So we have another question. Coming Star. Okay, Coming Star is asking, During public consultation, what if the voice of the people are against the project? Will it impact the grant of environmental clearance by the authority?
Yes, it will.
Yeah. So we have another question. Karthik is asking if there is a conflict between central and state government with respect to environmental clearance, whose decision will prevail finally?
Um, See, there is very clear bifurcation of powers here. So the projects are, as we discussed, categorized under A, B1, and B2. So as regards B1 and B2 projects, the state authorities will be granting the clearance. However, where the state authority has not been constituted, in that case, the central authority, that is the Ministry of Environment and Forest, is entitled to give clearance. So I do not think, I have not come across a case where there has been such kind of conflict. Uh, the areas of decision making powers are clearly bifurcated and divided.
Right. So we have another question from Anonymous attendee. Uh, the question is the order of Delhi High Court has been challenged in Supreme Court by Ministry of Environment and Forest. How far is the stand of Official Language Act for only English and Hindi valid?
Um, as I mentioned, so to illustrate, if a mine or if a thermal power plant is set up in, say, interiors of Assam, where the affected people will be tribals and Adivasis who know only how to communicate in their tribal language or at max maybe the language of the state. It will be very difficult for them to come out and give their responses without understanding what the issue is all about. Therefore, it is very necessary that people who will be affected know what it is that they will be affected with. Yeah? So if I do not understand what the project is about, uh, then I would be able to, give my or give my reaction or give my feedback. And again, if this is not done, it will go against my human rights and my constitutional rights as a person who is affected by the project. So now this can be challenge as to how many translations should be done in how many languages. Therefore, I think the decision of the Delhi High Court to translate it in 22 languages is reasonable, because if you look at the eighth schedule, uh, it covers most of the languages spoken in India. Now there are different dialects, I know, but I guess this is a reasonable decision to translate it into 22 languages.
Right. So we have a question from Anonymous attendee. The question is there a system in the notification where the public are educated about the information released from the industry for people from rural areas who can easily be misled by misinformation?
So public consultation includes that. So in the process of public consultation, you first educate the people who will be affected, give them a hearing, and get written responses from them. So yeah, it is covered under public consultation.
So there's a question from Anju. She's asking, there are many treaties signed by India. Whether this new draft is against any of the such
Any of the such?
treaties.
Can you repeat the question, Amisha, please?
Yeah. So Anju is asking, there are many treaties signed by India. Whether this new draft is against any of such treaties.
Yeah, it is against the treaty on EIA, which is also called as ISPO Treaty or ISPO Convention. So yeah, and of course it goes against the basic principles laid down in Rio Conference and Stockholm Conference. See, if you will look at the environment-related conventions, treaties, agreements, uh, environment impact assessment is an integral part of all these documents. So, yes, it does contradict these conventions and treaties.
Okay, so Sumedha, we have a long question in the chat box. It's by Amar. I'll just read it out for you. Courts have preferred regularization to breach of law, subject to compliance on broader terms. Examples, slum developments without permission are being regularized day in and day out. So why shouldn't industry who wants to improve its environmental compliance be allowed to regularize? Of course, there is a provision of compensation of past damage to environment. What is your take on this?
Um, Now, here I would say the principle of absolute liability will come in. So, going back to again the LG Polymers case. Now, there was a gas leak, people died, people were injured, uh, and uh, still there was no liability on. I mean, yeah, they had to pay some compensation, but that was it. Uh, so yeah, regularizing projects in these cases might set a dangerous precedent.
So we have another question. The draft of 2020 says it intends to reinforce transparency. Will the transparency really be maintained through this draft? What are your views?
Um, See, the preamble does mention this, but when we look at the provisions, I mean, in a pure academic sense, we see that even when a public consultation, when there are the provisions of public consultation, says that only limited information will be provided in public domain. Uh, so, you see there are two different points in one draft.
So is India again following discretionary model while proposing such a notification?
Is India
Following a discretionary model while proposing such a notification?
uh, discretionary model means where the decision making power is completely in the hands of authority. So mandatory model is where there is a rule, a notification, or a regulation. So India now follows a mandatory model. There is a notification. There have been multiple notifications, 1994 notification, 2006 notification, and now the proposed new draft. So India clearly follows a mandatory model, um, yeah, and not a discretionary model.
So if post facto is applicable across all projects, then what is the purpose served by specific exemption for certain projects?
Um, See, it is, how should I explain this? So few projects are exempted completely from getting environmental clearance. Whereas there are few projects where uh, environment clearance is necessary, but it can be regularized later on. So, yeah.
Sheila is asking, what about compliance to international conventions with respect to EIA?
Yes, so I did not get the question that clearly, but yeah.
Sheila, can you elaborate the question and post it again on the Q&A box if you're still in the session?
Yeah.
So I don't know if this is a question or a statement. It says, your talk gives an impression that 2006 notification was a holy cow. It was full of loopholes, and these loopholes are being deepened further by the 2020 notification.
I agree.
So,
And
okay,
I mean, in my presentation, I nowhere say that the 2006 notification was an ideal notification. There have been few, what we can say, lacunas in implementing what is written in books of law. But yeah, so I agree. I agree.
okay. So, there's a question. Okay, so Gayatri has elaborated her absolute liability question. The post facto clearance, is it not against absolute liability? For example, the LG case where it applied for clearance, the offenders can take a shelter under this draft even after committing the offense.
Okay, so yes, LG is liable to compensate the people who maybe have lost their loved ones or who are themselves affected by it. So they are absolutely liable for any environment damage as well as damage to lives. But uh, again, uh, how should I put it? I mean, yeah, taking a defense under the new draft is should definitely not be allowed.
So, okay, so this is a very interesting question, Sumedha, and
Yeah.
you're the best person to answer this. If we want to practice in environmental law, where should we begin from?
Uh, I mean, starting to practice first. I would say NGT. I mean, is there any other response to that?
Right. So I think this was from anonymous attendee. Do start your practice from NGT. Okay. So yeah, I'll take some questions from the chat box. Yeah. So Noor is asking, even after Visakhapatnam case COVID-19, is it right to pass this draft?
The draft has not yet been passed. It is still a proposed draft, and let's see how things develop in coming period.
Okay. So okay. Deepak is asking how much importance is given to environment economics real values used for calculating real value IRR instead of nominal value.
I didn't get the question.
Okay, Deepak, if you're still in the session, can you please rephrase this question? So, okay, this is a long question. I'll read it out. Ma'am, suppose the central government has finalized a decision on a certain project to be erected, which falls under the ambit of the central government only. But due to some reasons, maybe due to environmental reasons or some other reasons, does this concerned state government have to unwillingly accept the decision of the central government, or there are ways of resolving this issue?
Um, See, the notification is very clear. I mean, I have also not come across such a situation, but the notification is very clear that A projects will be given clearance by ministry, uh, and B1 and B2 projects will be given clearance by uh, state regulatory authority. Now, yes, of course, it's a moot question, and I mean, but I haven't come across such a situation for such an incident or a case.
So we have just like last few questions. We'll just take them. Suppose a coal mine is located in Jharkhand, whether the central authority need consent of state authority to grant environmental clearance as land is again a state subject.
Um, who has put for this question?
This is by Karthik.
Karthik, there's a schedule to the notification. Okay, so if you will go through the schedule to both the draft notification as well as the 2006 notification, you will see where the mining projects are placed. And based on that, again, just like I answered the earlier question, either the central government will give the permission or the regulatory state regulatory authority will give the permission.
Uh, yeah, right. So Rani is asking, do you think that the draft will affect the environment, mainly the northeastern states, which is rich, which is environmental rich?
Yes, it will.
So yeah, we have one more question. Do you think the present draft will save the environment? Perhaps economy of a country and individual economy depends on our natural resources.
I missed the first part, Anisha. Can you repeat
Do
it?
you think the present draft will save the environment?
Present draft will save the environment.
Question.
Um, Provided the gaps are filled in. Yes.
Okay, so Deepak has rephrased this question. For cost benefit analysis, whether real value economic internal rate of return is calculated or internal rate of return based on nominal value.
Um, I won't be able to answer this question because I'm not an expert in economics, but there are formulas for it. Yeah.
Okay, so Dr. S. Kusuma is asking, ma'am, thank you for enlightening, but do you think this really protects the population or promotes capitalism? Uh, Dr. S. Kusuma, are you asking about the draft? If you can just rephrase your question, we will take it up. Okay. So, according to 2006 EIA, what was the impact if the post grant EC in the half yearly report is adverse?
What was
What was
repeated?
the impact if the post grant EC in the half yearly report is adverse?
EC was rejected. See, EC is and again provided for a limited period of time, and if there are violations of conditions, then actions can be taken against the project company.
So I think we have answered all questions. Yeah, right. So, guys, in case of any questions, we'll just wait for a couple of minutes. You can post it on the chat box in the Q&A box. We'll be happy to take it up. Sumedha, anything else do you want to add? Thanks for the excellent presentation. I had no idea
Thank you.
about this. This is a very new topic for me, as well as we've received certain very good comments. So, Dr. H.K. Das is saying excellent interaction. Thank you, sir, for attending. Insightful session. Uh, yeah. So, thank you for the comments. Sumedha, do you want to add something?
Uh, I mean, I would request all of you to please keep a track of developments happening on this draft. And I mean, if you have any comments, any responses, please feel free to take this attempt and send your responses to the mail ID which I just mentioned. Yeah, that's it from my side. Thank you.
Thank you, Sumedha. Thank you, everyone, for attending. I was a law student. I am still a law student at heart, but I had no idea about what is going on in the environmental law domain. And Sumedha, thanks a lot for this session. Uh, we will keep on conducting such more sessions in the future. Do check out Lawctopus for updates. Also, if you wish to, ask any other questions, you can also mail us your questions on webinar@lawctopus.com. I'll just put it out for you in the chat box. Thank you so much for attending. Have a good day. Keep safe. Stay inside. Yeah. And we'll see you in the next webinar. Thank you.
Thank you so much, everyone. Thank you.